All right, another long list of problems for Sony Pictures. Former employees have now filed 4 lawsuits against the company. The suits claim the company ignored warnings about the attacks and failed to protect their personal information. The suits also claim the company knew its systems were vulnerable for years. The group responsible for the attack is called the Guardians of Peace. It says it has social security numbers of 47,000 current and former employees. Let's bring in our legal guys. Avery Friedman, a civil rights attorney and law professor, joining us from Cleveland. Good to see you.
Hi, Frederica.
And Richard Herman, a New York criminal defense attorney and law professor, joining us from Las Vegas. Good to see you.
Hi, Fred.
Okay, so Richard, you first. You say this really isn't a good case. Why?
Well, first of all, they hired David Boyce to represent Sony. So having said that, I think you can turn around and walk away. He may be the best attorney in the United States. But having said that, these cases are really, they're very, very difficult to prove. They'll probably get class action status. The damages in these cases are not large at all. It's more in a sort of remedial step to try to help Sony prepare in the future. But were they negligent? Were they reckless? Were these notices placed? Can they prove that Sony had knowledge that this was going to happen?
So even though these employees and former employees say that it was common knowledge that the system was vulnerable, even if they didn't have any real specificity of who might be hacking into it, that's just not enough? That's not enough of a defense?
This is the largest hack in the history of the United States.
Well, but the thing that I agree with is 95% of the existing protocols and systems essentially would have been defeated anyhow with this kind of hack. While I agree it might be a challenge, you know what, if you're one of the 15,000 employees and there were 35 million files released and put in the public domain, you're going to do something. And I think ultimately where this winds up is the matter is going to be granted class action status. There will be remediation. Systems, including encryption, will be put into place. But in terms of recovery, not very much. It's an important case principally, but in terms of the big load on the other end, the only people that will make out will be the attorneys.
So I wonder, I guess every employee would hope that they can entrust their employer. If I'm going to give you my social security number or anything else, that is personal, that you have a safe place for it. So isn't it the case that these employees would say, wait a minute, you offered us those assurances, but there are vulnerabilities, there have been vulnerabilities, and so on that basis alone, Avery, I can, build my case against you?
And that's what the theory would be. But again, the ultimate factual question is, were the efforts made by Sony Pictures and the corporation at large reasonably sufficient to protect employees? And that's the standard that a federal district judge is going to have to answer. I think it's likely, since we know the existing protocols are what most companies use. As technology evolves, yes, there are going to be better ones, but in a case like this, I think it's going to be difficult for the employees ultimately to prevail on the merits.
So, Richard, are there any other potential legal recourses?
Well, some of the legal recourses may be from the actors who's now the movie is not being put out there in the public, and they may have had a piece of the proceeds of the movie, so they could consider suing Sony based on that. I thought Rogan said he's not going to do it, but what's the claim? Is Sony's not releasing the movie? That's the claim. I'm contracted for a movie.
That's different than the employee claim.
We're talking about litigation, potential litigation we're talking about. We moved on from the employee claim. I don't think it's a viable claim, Fred. I don't think it's going to go. They may smoke and mirror it up. It's not going to. Nothing's going to happen from that.
The class action, Frederica, I think, is the minor legal issue. The big legal issue to me is the speech issue. How on earth? And we got a taste of Robert Linton's position that we'll see in more detail tomorrow. But the fact that there was a capitulation, and I agree with the president. I think there was. Hooray for George Clooney. Shame on the industry for not standing up.
What are you talking about?
Well,
the movie theaters wouldn't show the movie.
Right, and that was how Linton put it. He says,
wouldn't show
Linton says we didn't acquiesce. It wasn't Sony that made that decision. But if movie theaters say we're not going to show it, there isn't a venue, a place in which to show.
Between Sony and the exhibitors. I mean, maybe Mr. Linton talked about that, but it seemed to me the fear was corporate risk aversion. It wasn't about speech. It wasn't about expression. There should have been an effort. The idea of physical threats from a tin-horn dictator, come on. I mean, I think shame on the exhibitors.
In a movie theater,
this case should
and a
have gone
bomb
forward.
goes off in that movie theater, who do you think they're going to sue? They're going to sue the movie theater, and they're going to sue Sony.
That's not reasonable. That's an awful argument, I think.
It's foreseeable, and it would happen that way.
All right, and now we know what kind of arguments may have taken place in the boardroom there at Sony, right?
Right.
All right,
I'm
gentlemen,
sure.
stick around. We've got more. Another case that we want to talk to you about. This one involving the Ferguson grand jury, and word that some of the eyewitnesses lied and that the DA knew that. Straight ahead.